Hello everyone. Remedies for breach of contract. If a contract is done, there are even remedies if that particular contract is breached. So we look at the remedies for the breach of contract given by the Indian Contract Act. So talking about the remedies, as per the provisions laid down for the performance of contract, it also contains the provisions in case of breach by either of the parties. Remedies for the breach of contract means that when a promise or agreement is broken by any of the parties, we call it breach of contract. So either of the party breaks any kind of promise or agreement, then what it will be called? It will be called as breach of that particular contract. So when either of the parties does not keep their end of the agreement or does not fulfill their obligations of the contract, which were as for them to be fulfilled as per the terms of the contract, so it is called as the breach of the contract. So non-fulfilling of the contractual obligation also leads to breach of the contract. There are few remedies for the breach of the contracts available to the wronged parties. So what are the remedies? A remedy is a means given by law for the enforcement of right as such. Where there is a right, there is a remedy. So following are the remedies: rescission of damages, suit for quantum merit, suit for specific performance, and suit for injunction. So let's look at them in detail. Rescission of a contract. When one party to a contract does not fulfill its obligation, then the other party can rescind the contract and refuse the performance of his obligation. Means अगर एक party perform ही नहीं कर रही है उसकी obligation which the party was supposed to perform, then the other party can rescind that particular contract, और वो खुद ही मना कर देंगे कि आप perform करो ही मत because the time has gone, because you were not interested in performing it. As per the section 65 of the act, the party that rescinds the contract must restore any benefits it got under the said agreements. Means agar koi benefits liye in that particular agreement, then they are supposed to restore the same. And section 75 states that the party that rescinds the contract is entitled to receive damages and compensation for that kind of rescission. Next, when a contract is broken by one party, the other party may sue to treat the contract as rescinded and refuses further performance. In such a case, he is absolved of all his obligation under the contract. The court may give rescission due to contract is voidable or contract is unlawful. The court may also refuse to rescind if plaintiff has ratified the contract. Now, this ratification is again an important element. Parties can't be restored to the original position. The third party has acquired for value. When only a part is sought to be rescinded as per section 27 of Specific Relief Act. Next is suit for damages. So as per section 73, which clearly states that the party who has suffered since the other party has broken promises can claim compensation for loss or damages caused to them in the normal course of business. Now, a party who has suffered loss will claim for a damage or compensation. So, suit can be filed under section 73. Such damages will not be payable if the loss is abnormal in nature. So, now this particular is giving some kind of exceptions. So, such damages will not be payable if the loss is abnormal in nature or not in the ordinary course of business. So, there are two types of damages. So, to file a suit for damages, first of all, you need to qualify that what kind of damage it is. So there are two types of damages: liquidated damages and unliquidated damages. Liquidated damages, sometimes the parties to a contract will agree to the amount payable in case of breach. So this is a liquidated damages, means the amount can be calculated in terms of money. Unliquidated damages, here the amount payable due to the breach of contract is assessed by the courts or any appropriate authorities. So this amount can't be as such calculated, so that's why it's assessed by the courts or any appropriate authority. That's why it is called unliquidated damages. So on the basis of what kind of damage it is, it should be filed. Next, going forward, what are the damages? Damages basically are monetary compensations allowed to the injured party by the court for the loss or injuries suffered by him by the breach of the contract. The objective of awarding damages for the breach of contract is to put the injured party in the same position as it was. So that's why this is a doctrine of restitution as well. The fundamental basis is awarding damages for the pecuniary loss. Next remedy is suit for specific performance. Now this means the party in breach actually have to carry out his duties according to the contract. The suit for specific performance can be filed. In certain cases, the court may insist that the party carry out the agreement. So if any of the parties fail to perform the contract, the court may order them to do so. There's a decree of specific performance and it's gains instead of damages. For example, A decided to buy a parcel of land from B. B then refuses to sell. Then the court can order B to perform his duties under the contract and sell the land to A. Specific performance in certain cases of breach of contract damages are not an adequate remedy. These damages can't fulfill any kind of adequate remedy as such. The court may in such cases direct the party in breach to carry out his promise according to the terms of the contract. This is a direction by the court for specific performance of the contract at the suit of the party not in breach. Cases for specific performance to be enforced when the act agreed to be done in such that compensation is not an adequate remedy. So if compensation is not an adequate remedy, then only the suit for specific performance can be enforced. When there is no standard for ascertaining the actual damage, means the actual damage can't be ascertained. When it is probable that the compensation can't be agreed to be done. Next we have is injunction. An injunction is basically like a decree for specific performance, but a negative contract you can also call it. An injunction is a court order restraining a person from doing a particular act. So it's a restraining order from the side of the court which restrains a person from doing a particular act. So court may grant an injunction to stop a party of a contract from doing something which he promised not to do. In a prohibitory injunction, the court stops the commission of an act, and in a mandatory injunction, it will stop the continuation of an act that is unlawful. So court may at any time grant an injunction to stop a party of contract from doing something. Something is what which he has promised to do or not to do. So it's some kind of prohibitory injunction to stop the commission of an act, or you can call it a mandatory injunction. It will stop the continuation of an act which is unlawful in nature. Injunction is basically when a party is in breach of a negative term of contract, the court may, by issuing an order, restrain him by doing what he promised him not to do. Such an order of the court is called injunction. Court refuses to grant injunction whereby a promiser undertakes not to do something which is negative in substance, though not in the form. Next remedy is quantum merit. Quantum merit literally translates to as much is earned. At times when one party of the contract is prevented from finishing his performance of the contract by the other, he can claim quantum merit. So he must be paid a reasonable remuneration for the part of the contract he has already performed. Means he has performed, one of the parties performed his part, but the other party stops the performance in between. So the other party, what the agreed party can do is can file for quantum merit. So the party will be provided with a reasonable remuneration of the part which he has done, so that the monetary loss can be compensated. This could be the remuneration of the services he has provided or the value of the work he has already done. The phrase quantum merit literally means as much as earned. A right to sue on the quantum merit arises when a contract partly performed by one party has been discharged by breach of contract by the other party. A party has partly performed it, but its breach has been done from the side of other party. This right is performed not an original contract but on implied promise by other party for what has been done. So this is all with regard to the remedies for the breach of a particular contract. Thank you.